All right, well, it's 6:01. I say let's get started.
Okay.
Good evening and welcome to the final Tenant Tuesday program for Fair Housing Month. Um, this, this program has been part of a series of 4 Tuesdays where we have touched on many different aspects of the landlord-tenant relationship and their respective rights and obligations. So a little bit about us. The Office of Consumer Protection's main goal and mission is to help you resolve your disputes with merchants and landlords. We are available by phone, by email, or in person if you have questions about what your rights and your obligations may be. We also enforce the various consumer protection laws of Howard County. We do a lot of programming, so if anything is of interest to your community group or civic group or any other kind of organization, please reach out. And we also license peddlers and solicitors. It's the season for door-to-door sales. Please ask for our ID that we issue. And if they don't have them, please, by all means, let us know what company is coming to your door so we can get them in compliance. And we also regulate and license trespass tow companies. On the side of the landlord tenants, the main thing that we deal with are items that are coming out of the lease. If it's a money question or if it's a contractual issue. Our first program this month was with the Department of Inspections, Licenses, and Permits. They are the ones who license landlords and make sure that the home is safe and in good working order. We also will handle all of the disputes that do come. We try our best to resolve. Not everything is resolvable, but we do our best. And we're definitely here to try and keep things out of court if possible. And you can get a lot of information on our website on consumer issues as well as landlord-tenant issues. So today we are really thrilled to invite Todd Gibbons. He is with the Howard County Office of Human Rights and Equity. And he's going to be talking about housing discrimination and fair housing laws in Howard County. So Todd, I am going to let you run with it.
Okay. Good evening, everyone. As Tracy's already said, my name is Todd Gibbons. I am the lead investigator and compliance officer here at the Office of Human Rights and Equity. And we want to talk about on our fourth and final Tenant Tuesday a little bit about understanding some fair housing protections. And before we get into that, I wanted to just thank Tracy Rezvani and her staff at Office of Consumer Protection for inviting me and for having these Tenant Tuesdays in commemoration of Fair Housing Month. You probably already know that April is Fair Housing Month, and on April 11th, 1968, the Fair Housing Act was passed. And the Fair Housing Act was passed in part as the right of individuals and families to access the housing of their choice without being subjected to discrimination. And so since that time, Housing and Urban Development, along with our office and state offices, have all been engaged in trying to combat housing discrimination, which is in line with the with what the Howard County Code says as well. I think I just saw something that if you have a burning question during the middle, you can stop and answer it. If not, I'll take some questions at the end. And also, any of the stuff on the slide deck is going to be available, and Tracy's going to put up some information as to how you can get it, so you don't have to worry about that part. So let's just talk a little bit about housing discrimination and how it works. Well, let me tell you a little bit about our office first before we get into some of the things that we commonly come across. And I want to talk about essentially two areas, maybe three, that we often come across as far as allegations of discrimination as it pertains to fair housing. But before I get to that, let me just tell you a little bit about us. Our office was founded in 1975, and the mission of our office is in line with the Howard County Code, which is in our section, and I'll refer to that a little bit later. Our section of Howard County Code that's applicable to discrimination, whether it be employment or housing, whatever the case may be. It's Title 12, Section 2. I'm sorry, Title 12, subtitled to Sections 12-200 through 12-221. And that's the code that basically sort of it governs how we operate, and also along with the Fair Housing Act, which if you look at our code, is pretty much similar to what the Fair Housing Act says. Also, I'm going to try to refrain from something because I told my wife that I was going to be doing the seminar tonight, and she said, you're going to have the tendency to talk a lot, and don't do that. And she reminded me that words are powerful as long as you don't use too many of them. So I'll try to keep that in mind and hopefully be brief and be bright and be gone. But anyway, so let me just tell you. So our Office of Human Rights and Equity is founded in 1975, governed by the code, Howard County Code, Title 12, Subtitle 2, easy for me to say, Sections 12-200 through 12-221. Our office consists of 3 units: the investigations unit, the outreach unit, and the equity and restorative practice unit. And the outreach unit is, hopefully you've seen us at various events with tabling events, or we're doing different things to let you know basically that we're here and that we're available. And so we try to go out to many of the events. You may have seen us at such stuff like the AAPI Festival, or Caribbean Heritage Month, or any one of a number of things that you probably see us at a table somewhere to let you know that we're here and engage with folks. The other part that we do, we have an equity and restorative practices unit, and primarily that's basically taking an internal look at how we do stuff in the county to make sure that we in fact are following fair and equitable practices as far as how we, whether it be if we're doing grants or however we as the county interact with the public at large. So our investigations unit, specifically what we're trying to do, we're investigating complaints of discrimination. We also try to resolve complaints by conference, mediation, or conciliation, and sometimes litigation if it goes that far, but essentially we are trying to enforce the Howard County Code. Now, the areas of investigation, primarily what we do is 5 areas: housing, and you can change the slide, housing, employment, public accommodations, finance, and law enforcement. So tonight we want to talk a little bit about the housing investigations that we do. And so to that end, again, the code is spelled out in Section 12-207. And essentially, the purpose of these laws and the purpose of the Howard County Code and the Fair Housing Act, these laws are designed to protect people from discrimination, whether they are renting, whether they're selling, leasing, or buying, whether it's renting, selling, leasing, or buying a home, getting a mortgage, or engaged in other housing-related activities. So now, how these things sort of start is we start talking about protected classes, and you can change the slide. So you'll notice that in the Fair Housing Act, there are 7 protected classes, and some of them are captured here, but there are also additional ones. In the Fair Housing Act, you have race, you have color, and this is federal law. You have religion, you have national origin, you have sex, you have disability, and you have familial status, which is essentially referring to households with children under 18 in a household, or somebody who may be pregnant, or someone who is in the process of adopting or securing legal custody of a child. So essentially how that might work in our office, if for some reason somebody was trying to rent or buy and the prospective landlord was making comments or indicating that they may not want the particular person to rent or buy because they either because they're pregnant or because they have a number of children or that sort of thing. So that's sort of how it comes up as far as possible discrimination or complaints that we may get. But you will also note that on the slide here, it shows that the county has additional statuses that are not under federal law. So essentially, we have more protections that you will find under federal law. So you have marital status, you have sexual orientation, color, national origin, familial status, but also age, citizenship, political opinion, personal appearance, sex, disability, gender identity, source of income. And so I'm going to talk about, this is where I want to talk about two of the protected classes that we get a lot of issues or complaints related to. One is source of income and the other is disability. So I'm going to talk a little bit about disability and then we'll get to source of income. But so disability comes up a lot as far as these complaints are concerned. And under the Fair Housing Act, it is unlawful to discriminate against somebody in the renting, selling, buying because of their disability. It's against the law to do any of these things based on any of the protected classes, and any of those things such as refusal to rent or sell housing, refusal to negotiate housing, making housing unavailable or deny that housing is available, or setting different terms, conditions, and privileges for the sale, rental of housing, and advertise in a discriminatory manner. Like, for example, when I first started working here back in 2014, and this wasn't the case in Howard County, but it was the case in Baltimore County, and when I'm talking about advertising, for example, you could advertise once upon a time in Baltimore County, for example, that you didn't want to rent or sell to somebody with a housing voucher. And it's not the case now because in Maryland in 2020, Maryland passed the HOME Act and housing opportunities made equal. And so that took the source of income, that made source of income discrimination illegal as well. Now, Howard County already had that protection. But again, I want to talk a little bit about disabilities before I get to source of income. And so, again,
you want me to go backwards? I'm sorry.
If you just go backwards one, that's fine. And then I'll let you know when I'm about to switch over. So let's talk about what a disability is, because there's often question about that. So we'll just start there. So a disability is defined by both federal law and local law as a physical or mental impairment that substantially limits one or more of a person's major life activities. And so major life activities can be such things as caring for yourself, walking, seeing, hearing, that sort of speaking, breathing, those sort of things. But the disability definition has also been expanded under Fair Housing Act to include people that have history of an impairment or they're perceived as having an impairment even if they don't. Now, just to be clear, disability does not apply under federal law and state law or local law if somebody's using illegal drugs. But generally, most people come under some type of definition of disability. And so that's not usually the issue, but it can be an issue. Once upon a time, the person had to essentially prove that they're disabled, but usually we don't have as many issues about proving that they're disabled because the definition of disabled is so broad. So what does that look like as far as once we've established what disability is? So it could be any one of a number of things. For example, it could be a landlord who tells a prospective tenant that they don't want someone with a disability living on their property. I know you probably don't believe that happens, but it does from time to time. It could be a rental agent indicating that an apartment is not available to a prospective tenant when in fact a prospective tenant with a disability when in fact there are units available. It could be in the form of charging double the amount of security deposit because a tenant uses a wheelchair or a scooter. It could be something like requiring people requiring people with mobility impairments to live on ground floor units. It could be not responding extremely slow or not responding at all to maintenance requests with people from disabilities. Or it could be attempting to evict a tenant because they request a reasonable accommodation or file a fair housing complaint. And I'll talk a little bit about that in a minute. Or it could be refusing to renew the lease of a person whose disability-related symptoms have become more severe during a lease term. So that's not all of them, but I just want to give you sort of an ideal of the sort of type of complaints that we get related to disabilities. Now, I want to talk a little bit about reasonable accommodations because this term gets used a lot. So I want to make sure you understand what it is, because sometimes there's two terms that you need to know as far as fair housing laws are concerned. One is reasonable accommodations and one is reasonable modifications. And most of the time people just use them all and just mash it under reasonable accommodations. But under the law, they are two separate things. So what is a reasonable accommodation? A reasonable accommodation is a change in rules, policies, practices, or services that enables a person with a disability an equal opportunity to use and enjoy a dwelling. So I'll say it again. A reasonable accommodation is a change in rules, policies, practices, or services that enables a person with a disability an equal opportunity to use and enjoy a dwelling. Here's some examples of a reasonable accommodation. It might be assigning a person with a disability a reserved parking spot near their unit, although the tenant parking is generally first come, first served. That's one example. It might be allowing a person with a disability to keep an assistant animal despite a no pets policy. It could be allowing an assistance animal waiving the pet fee policy. It could be an example, allowing a disabled tenant who gets their sole source of income as a disability check, and it might be allowing them to pay after the 5th, because usually when renting, the rent's due on the 1st of the month and usually late after the 5th, but it could be a case where that might be their only source of income and the check may come after the 5th, so that could be possibly a reasonable accommodation. It could be providing a lease application in large print. It could be allowing a transfer to a first floor or more accessible unit in a community. So this is not necessarily the exhaustive list, but these are some of the things that come up under reasonable accommodations. Then the other part is a reasonable modification. A reasonable modification is a change to the physical structure of a dwelling that enables a person with a disability equal opportunity to use and enjoy that dwelling. Again, this is a change to the physical structure, whereas a reasonable accommodation is a change to a rule, policy, practice, or service. So what does a reasonable modification look like? It could be installing ramp access to the entrance of the dwelling. It could be installing visual or tactile alert devices. It could be widened doorways in a unit. It could be something like installing grab bars in the bathroom of the entrance unit. It could be maybe removal of below counter cabinets, or maybe replacing door handles with levers. So again, it's not necessarily an exhaustive list because it's always a matter of facts and circumstances, but these are some of the things that are considered reasonable modifications. The primary difference is that generally the expense for reasonable modifications is the responsibility of the tenant. So again, reasonable modifications, general rule might be at the expense of the tenant. Reasonable accommodation is usually something that the landlord would have to do. So another thing that comes up, how should a resident or prospective resident request a reasonable modification? So always, if that comes up, always do it in writing. You can, or send an email so you have some record of it. Because if you just go and then they say, well, I told them I needed a reasonable modification, and they're going to say, well, we didn't have any record of it. And in some cases, and I don't know if this is true for every case, Tracy, but I know some of the current leases, they'll say you can use our form to request a reasonable modification. I don't know if that's the case in every lease, but I've seen it before. You're not necessarily required to use their form, but you should definitely put your request in writing so there's no dispute over whether you actually made it or not. And there's examples as far as if you look at HUD, as far as some what the letter looks like, but you don't have to be, it doesn't have to be elaborate, but you do want to say, I'm requesting a reasonable accommodation if that's what it is, or a reasonable modification. And you should be specific as to what it is, so there's so there's not any confusion as to what it is that the person's asking for. Now, sometimes the landlord may say, well, they didn't use our form. Well, under Fair Housing Act, you're not required to use their form. I would just say if they have one, use both, and then you have a copy for yourself. I would also send an email or send a letter along with their form if they have one. But the main thing is that you want to have something that you can hold on to say, I did make the request, so there's not a dispute. So, when must a housing provider allow in a reasonable accommodation or a reasonable modification? Well, generally, that's when you want to look at a couple things. Is the person disabled? Are they making the request under the definition of a person? Are they disabled under Fair Housing Act or the general definition of a disability? Is due to their disability, they need the accommodation or modification in order to use or enjoy their dwelling. And the request is reasonable. And that's oftentimes where there's some dispute as to what the request is and is it reasonable, because it does have to be a reasonable modification or a reasonable accommodation. So how does that look? Well, one thing you might look at is if it's reasonable, does it cause an undue financial or administrative burden to the housing provider? Does it cause a basic change in the nature of the housing program available? Will it cause harm or damage to others? Is it technologically possible? For example, if you had a person who becomes disabled, they may not have been disabled when they first moved into the unit, but they're disabled now and they can no longer access their third floor apartment in a non-elevator building. Let's say it's an old building, and it's probably unreasonable and perhaps not even architecturally feasible to request that the landlord put in an elevator. So what might be a reasonable request, they may want to transfer to a first floor apartment, or if that's not possible, they may want to get an early release from the lease. So that might be what's considered a reasonable accommodation in that case. So it's always going to be a question of what's reasonable. So it's not automatically I'm making the request so I get exactly what I request, especially if there's something else that that might be able to be done that would allow the landlord to allow the tenant to use and enjoy the property. So again, you make the request in writing, and then if the housing provider thinks that the request is unreasonable, then that's when you do what we call a dance. And it's just an acronym. So first of all, does the tenant have a disability? Okay. A, are they requesting a change are they requesting an accommodation? And if it's accommodation, it's rules and practices. 3, is it necessary? And 4, what's the cost? And then 5, what's the effect on the business? So if you look at those are usually the 5 factors we're trying to determine if we're looking at whether this accommodation is reasonable or not. So is a person disabled? Is it an accommodation? Obviously, they're requesting some change to rules, practices, and services. Necessary, for the full use and enjoyment of the property? What's the cost of it? And then what's the overall effect if this happens? But again, in order to start that process, I would suggest that you always put it in writing. Another thing that I wanted to touch on briefly, we get questions about, and this comes under the reasonable accommodation period, is assistance animals. And I guess to some extent, emotional support animals sort of fall under that, even though they're considered under FHA rules. They're two separate kinds of animals, because an assistance animal essentially does a service, so to speak, where an emotional support animal may have more of a psychological effect. So again, but for example, if you're requesting a waiver for the pet, if your place has a no pets policy or fees for a pet, and you may be requesting a waiver for that because you have an assistance animal, then again, you can provide that information. You don't have to, you're not required to go into all of the details. But sometimes the needs for animals may not be obvious. So, you may want to just, have your medical provider. I mean, if it's obvious, you don't necessarily have to go through that. But if it's not obvious sometimes, and it's not obvious always especially with the emotional support animals, that you might want to have you should probably have a medical provider send that complex some information indicating the need for the emotional support animal. The other thing now, if you want to change the slide, Tracy, I want to talk about a little bit, because we get this a lot, is source of income. And source of income is essentially what it sounds like. It's how you get your income. And it could be through any one of a number of different ways. I mean, obviously it could be from your employee, it could be from your employment. It could be from some type of rental subsidy that you may be getting. It could be veteran benefit. It could be disability check, and it could be housing choice vouchers. And this is the one that we normally get a lot of. Housing choice vouchers, as you probably know, is essentially is essentially given by Housing and Urban Development to people who have certain income to help allow them to be able to obtain housing. Usually what happens is the housing choice voucher, the voucher program, pays a portion of the rent, and then the tenant is responsible for paying the other portion of the rent. And as you noticed when I said earlier that when I first came, that people could say we didn't want housing choice vouchers in their advertising, and you can't do that anymore now. But, still we get issues about housing choice vouchers all the time. And because unfortunately there are some stigmas that are connected to housing choice vouchers. But again, now sometimes I'll push back, because now when we were in COVID, there were certainly no issues about vouchers, because landlords were getting at least a vast majority of the money. But again, source of income. You can't advertise no vouchers allowed. You should be, as a landlord, using the same equitable terms and conditions as you would do for somebody who's paying market rate. You certainly don't say, we don't accept vouchers. And as a landlord, you certainly should not be charging higher rent or higher security deposits due to a voucher example. So those are oftentimes come, and basically how it looks when we see it. The voucher holder may say, hey, I was trying to rent this place, and I gave them all my information and everything looked good. And then, I told them I had a voucher, and then all of a sudden everything changed. And I don't know what happened, but then they didn't want to rent it to me, and then they rented the place out to somebody else. So those are the sort of things that we look at to try to determine, is this person, are they being discriminated because of their source of income, or is this some other issue that's going on? Now, who knows? We don't know until we actually start looking at it. Who knows? Maybe it was maybe something related to criminal history or maybe related to creditworthiness or those sort of things. We have to look at the totality of circumstances to try to figure out what it is. But these are just sort of things that we normally sort of get, or complaints that we get as far as issues related to source of income. The other thing, and it doesn't occur as much now, but when I first came, we used to have a big issue with income requirements. You can change the slide. And so one of the issues is that, like I said, when folks have housing vouchers, the voucher pays in a portion of it, but the tenant is still responsible for paying their portion. And so one of the things that used to show up is under the income requirements, if the if they would say like you'd have to have 2 times for your rent, your income requirements, you have to have 2 times the rent. Oftentimes many apartment complexes would say, and now obviously if that's the case, hardly anybody who had a voucher would be able to afford it, because that's part of the reason. That's the reason they have a voucher, because they have a low income. And so now I think for the most part we haven't had that as much, but it used to come up a lot. And so it used to be that they would say, well, hey, this person doesn't make 2 times the rent. Well, hardly any voucher holder would, but they have to have, it might be 2 times their portion, which they can usually make, and it allows them to be able to rent. So that was one of the things that we used to get a lot. Some of the other things that just prohibited activities in general: a refusal to sell or rent, discriminatory terms and conditions, advertising. And usually this is first when it comes up, because essentially what we always tell anybody who's a landlord or anybody who's thinking about renting, once you advertise, it's available to whoever comes to. Now, obviously, sometimes they may be coming around the same time, and we'd have to sort of sift through that to try to figure out what that is. But once you advertise, you can't exclude anybody. So now, if Tracy and I are good friends and we just happen to belong to the same social organization or something, and we just have a conversation and say, hey, I got a place to rent, and you're interested in renting it, and she says yes, that's different. That's not advertising. But once it's out there in Zillow and the papers and all that sort of thing, then you're advertising. And so once you're advertising, you basically have to treat everybody equally in that sense. No blockbusting or steering, no harassment, threats, and coercion. You can't use any discriminatory covenants, even if there was something in the lease that said you can't rent it to, African Americans. You can't say, well, the lease said I can't rent it to African Americans. So you can't retaliate against anybody for. Usually, what happens in that sense. Usually what retaliation looks like is a couple things. Number one, it might be like, I'm already a tenant and I have said that I'm going to complain with respect to you not fixing things properly, or you're not doing something, and then they try to put you out for that, evict you for that, or something like that. Or you say that I'm going to file a complaint because I feel like I'm being treated unfairly, and for some reason either you don't get the place, or if you're already in the place, they may try to evict you. That's sort of how retaliatory stuff looks in what we get. There are some exceptions under fair housing. Some of the things that you may see, like, for example, age-related dwellings, so like senior citizens. So obviously, if it's a 55 and over complex, then you're not going to be successful in saying that they wouldn't discriminate. I mean, they wouldn't rent to me because I had children or familial status or whatever, because that's the whole thing behind those age-related dwellings, that at least they have restrictions on who can be in there and the ages that they have to be. Owner-occupied dwellings, usually that comes up occasionally. Like, for example, if I had a small unit and I lived in it too, so those are sort of outside of outside of the general Fair Housing Act protections. Private membership clubs sometimes comes up if it's truly private and the membership is not discriminating against, generally not discriminating against the protected classes that I talked about earlier. Some exceptions are threats to health and safety. And so because the person's disabled, if it can be shown that they are a threat to health and safety, that could be an exception to the fair housing laws. Maximum occupancy, those laws still apply. So essentially you may not be able to have, just because of a disability or whatever, 20 people in the room or something like that is not going to be, is going to be outside of outside of Fair Housing Act protections. And so we're going to show you the information where you can get in contact with us, but I said I wasn't going to talk too much, but I'm afraid I may have. So at this point, I'll stop talking for a minute and take some questions if anybody has any.
I don't have any questions in the chat. So we can on to the minimum income requirements if you'd like.
Yeah, and I did talk about them a little bit, but like I said, we don't get it as much, but we certainly got when I first got here. I'll just give you an example from the slide. So essentially, it would be discriminatory if the landlord had the housing voucher, because a lot of times, I think, if I'm not mistaken, at least 2 or 3 times of the total rent is sort of standard for minimum income requirements in the leases. So obviously, as I mentioned earlier, that type of policy would basically push out any voucher holder, because if they could, they could make 3 times the total rent is $2,000, and they're making 3 times that, and they're not going to be, they wouldn't qualify for a voucher. But as the example on the slide, if the total rent's $2,000 and the tenant's portion is $200, the voucher is obviously going to cover the $1,800, and the minimum income for the tenant would be 3 times their portion of the rent, not 3 times of the total rent. Because like I said, if they're making $6,000 a month, then they're not going to qualify for a housing voucher. But if the minimum income requirements were just standard for everybody, then obviously nobody who had a voucher would be able to rent. So part of that was to give the voucher holder an equal opportunity to be able to rent, in throughout the county or throughout the country for that matter.
Got it. And these were the exceptions that you were mentioning.
Yeah. So again, so example, you'll see usually the 55 and over dwellings, we don't usually see private membership clubs, because I don't know if there's a lot of them. It's certainly not with respect to renting places. Same with religious, or I know there's some places where churches have, apartment complexes. I don't know if that's the case here, but I know there are some, throughout in other parts of the state, I believe. The other one I didn't mention is, well, I touched on it a little bit, is sale or rental of a single family dwelling without a broker, agent, or advertising. So again, this is where I am trying to rent. How do I go about? I'm sorry, I see a question. How do I go about
switching from income to a housing Section 8 voucher?
Okay, so you would have to contact the Howard County Housing Commission and they would be, because the Housing Commission essentially operates the voucher program for HUD here in Howard County. And so the Housing Commission would basically have to make the income reviews and determine whether you would be eligible for a voucher or not.
And we had a program last Tuesday where the Housing Commission and the Department of Housing talked about the various programs that are available. So if you missed that, I do have that as a recording. So if you email us, I can send that link. And I just want to make sure that we had touched on everything.
Oh,
Step
sure.
filing a complaint.
Yep, I was gonna get to that. So yeah, so basically, if you feel discriminated against, or if you know somebody who feels like they've been discriminated against, there are certain steps that we'll do. And the first thing is you can contact us, and I know the last slide is our contact information, but I'll just say it anyway. It's ohre@howardcountymd.gov, ohre@howardcountymd.gov. I used to be in radio sales once upon a time, so they said you have to say it at least 3 times. ohre@howardcountymd.gov. So you can email us, and we'll do the initial intake. So or you can call us. We still take calls too, and we'll do the initial intake, and we'll set up an interview with you. And after setting up the interview, and partially is to get more information about it, because sometimes the information that we get via the website is not often very informative. So, but it's enough but we'll call you, and we'll certainly talk to you and try to flesh that out. And we'll send you a pre-complaint form and checklist to check off all the things, make sure that we haven't missed anything with respect to your complaint. We will draft the charge of discrimination for you, so you don't have to worry about drafting it yourself. So we'll draft that for you, send it to you for your review and signature. Once you've done that, we send a copy of the complaint to the respondent, and then they'll respond, and again it's assigned to an investigator, and then the investigation begins. So we'll sort of update you throughout the process, but we'll help you with all of that, so you don't have to worry about writing the charge or everything. We just need to, once you indicate that you feel like you've been discriminated against, and we do want to meet with you and get the background on the information, because obviously, keep in mind, at this point, we've only got one side of the pancake, which is the person filing the complaint, which is ultimately after we draft the complaint, we send it to the respondent, because we have to get a response from them, and then that's when we start the sort of process to try to figure out whether we think the person's discriminated against. So thank you so much for your time. We appreciate you, and appreciate you taking part in the Fair Housing Month process, because this is, it's not only a commemoration about Fair Housing Month and the fact that the Fair Housing Act was passed in '68, but it's also designed to be educational. And so that's why, again, I want to thank Tracy and her team for, first of all, inviting me and everybody else who's taken part of all the Tenant Tuesdays. So thank you so much for your time, and I appreciate it.
Thank you. And obviously you want to follow Office of Human Rights on social media, and here's their handle. And a great big thank you for everyone for being with us for this Tenant Tuesday webinar series. And we look forward to providing more programs in the future. And a great big thank you to Todd for giving us this program. And the slides and the recording will be emailed out to everybody who registered. And if you missed a prior program, let us know. We had one on, as I mentioned, licensing and habitability, housing code enforcement. We had a program that talked about the Tenant Bill of Rights and how to deal with leases, security deposits, etc. And last week it was the Housing Commission and Department of Housing with low and moderate income housing programs. And obviously today we had Todd on human rights and equity. So please, I put our email address in the chat. It's consumer@howardcountymd.gov. And if you'd like to get a recording of one of these webinars that you missed, please email us and I will get it to you. All right, well, thank you so much. And we will call it a day, and it will be a few days before I can get the webinar clipped and sent around. Thank you.
Thank you so much. Appreciate it.
Bye.
Good night.